Okay, Paul, I think I'm going to kick off our meeting. Let's do one quick audio test on your end, please.
Can you hear me all right?
I can hear you just fine.
Great.
Perfect. All right. Audio's working, video's working. I think we're good to go. Well, good morning and welcome, everyone. Thank you for joining us for today's webinar, Capturing and Protecting Your Company's Intellectual Property. My name is Jason Castor, and I'm the Chief Business Development Officer for Parsons Behle Latimer, and I'd like to welcome you to today's presentation. Thanks again for taking time out of your busy schedules to be with us this morning. Before I introduce our speaker, I want to cover just a few quick logistical items. First, today's webinar is being recorded, and you'll be provided a link via email to the recording to share with your colleagues and teams. This email is also going to contain a copy of today's PowerPoint presentation, so you don't have to take copious notes throughout. Second, CLE credit in Idaho, Montana, Nevada, and Utah is pending. Our follow-up email will include a request for names and bar numbers for those interested in obtaining CLE credit in those states. Third, related to Q&A, we have allotted time at the end of today's presentation for a Q&A session. Please feel free, however, to use the chat feature to submit your questions throughout today's discussion, and we'll do our very best to address your questions before the conclusion of today's presentation. And finally, it's important to note that today's presentation is considered a general source of information and should not be considered a substitute for legal counsel. You should not act upon the information in this presentation without consulting with your legal counsel. So with that, and housekeeping items aside, I'd now like to introduce our speaker, Paul Evans. Paul, thanks for being with us today. Paul is a shareholder in the firm's Idaho office. His practice focuses on business transactions with an emphasis on the development and the protection of intellectual property assets. He has more than 25 years of experience with law firms and as a corporate executive in a wide range of legal matters, including all aspects of intellectual property protection and litigation. So with that, Paul, I'm going to turn the time over to you. Thanks again for being with us this morning. Thanks again for taking the time to prepare today's presentation. I'll turn the mic to you.
Good morning and welcome to this morning's presentation on capturing and protecting your company's intellectual property. I want to thank my firm, Parsons Behle Latimer, and in particular Jason Castor, for hosting this webinar and extending the invitation to all of you. My goal this morning is to expand your current thinking in terms of why is it important to have an IP strategy and what IP assets does your company currently have that you can protect. Regardless of your level of familiarity with the various forms of intellectual property protection, I hope that you will find today's presentation helpful. And as Jason said, I will reserve time at the end for Q&A. This morning, I will cover the various legal processes used to capture the intangible value of intellectual property. In other words, your company's creativity, and I will also discuss how to identify, value, procure, monetize, and enforce IP protected assets. In an economy powered by knowledge and creativity, IP is a significant corporate asset for companies in virtually every industry. And it enables businesses to create value in a variety of ways, and it helps companies gain a sustainable competitive advantage. It's estimated that about 60 to 80% of companies' assets today are intangible. They include brands, technology, know-how, as well as the legally protected assets defined as intellectual property. Some of the questions that I want to address today, for example, is how do you ensure that your company has the rights that you need to conduct and grow your business? Now, there are various important aspects of IP to look at as you do this. It includes patents. Do you have freedom to operate? If you have technology or products, making sure that you're not infringing other third-party patents. It could include copyrights, trademarks, making sure that a trademark that you select for your products or your company, that it's not infringing another company's trademark, for example. And innovation-based investment can be very expensive and risky. So by protecting it with intellectual property, you you increase investor confidence in the long-term potential of the company. Now, creativity creates value for your company, and your IP assets reflect the value of creative potential in your business. And intellectual property, importantly, allows you to increase your competitive advantage in the market space. It could be things such as your brand, your reputation, and the various product offerings that you have. I'm going to cover today the four main areas of intellectual property, which include copyrights, trademarks, trade secrets, and patents. And as I go through these various areas, be thinking in your mind, ask the question about, and consider your business. What are some of the areas that you may not be protecting these IP assets that perhaps you should be? The first one I want to go through is copyrights. Now, copyrights are expressions of ideas, and examples include software, databases, publications, art, literature, video, music, architecture, performance, recordings, and so forth. And it's important to remember that copyrights protect against copying and distribution, but they don't protect the idea. And that's where the other forms of IP protection come into play. And I've highlighted here on this slide a couple of elements that are required whenever you need to show or want to show copyright infringement. First, you need to show that you have a valid copyright ownership. And second, you need to show that the copying is the constituent elements of the work and that they're original. In other words, you need to show that the infringing copyright is substantially similar to your copyright. And a very important example of copyright protection is software. And oftentimes, software is primarily protected through copyrights. The next category I want to talk about is trademarks. Trademarks are particularly important for branding purposes and protecting the value of the reputation you create for your business. And examples of trademarks are any word, symbol, logo, or combination of these used to designate the origin of your goods or services. And I'm sure you've all seen a trademark with a circle R, which represents that mark has received government registration under the Trademark Act. You've also likely seen the TM or SM for TM is for trademark, SM is for service mark superscript symbol, which indicates common law protection. And the various states do have common protections under state law for trademarks. And however, I want to emphasize that the value of seeking a federal registration for your trademark is the protection provisions and the enforcement provisions that are offered under the Trademark Act, which are very much more extensive than most of the protection provided under states. All right. The next category I want to talk about is trade secrets. And why? So I asked the question, why are trade secrets important? First, they protect ideas that offer a competitive advantage for your company. Examples could include valuable business information. It could include proprietary know-how in your technology. It's important to recognize too that there isn't a governmental registration process, so it's simpler and relatively inexpensive. And frankly, it might be the only protection available. If, for example, we'll talk about this in a minute, but under the Patent Act, there are certain statutory bars. And so you need to make sure that if you desire patent protection, that you get a patent application filed before there's any potential bar. And I'll talk about that in a minute. The other value of a trade secret is there's no expiration date. And I want to add here, oftentimes with clients and with companies I've been at previously, there's a lot of thought and strategy that goes into which type of intellectual property protection that's sought. And for example, with software, if you don't feel like you can get broad patent protection, it may be better to keep it a trade secret. If it's something that's easy to reverse engineer, for example, there's not going to be much value in a trade secret. So oftentimes you want to seek multiple forms of protection, whether it's through trade secrets and patents and copyrights. I've included here a slide on, there's a federal trade secret that's called the Defend Trade Secrets Act, and there are extensive protections that are afforded under this act, and importantly, it sought to harmonize the protections and the definitions. And so I've included in here the type of information that can be considered a trade secret. And I'll just quickly go through this list. It includes all forms and types of financial, business, scientific, technical, economic, or engineering information, including patterns, plans, compilations, program, devices, formulas, designs, prototypes, methods, techniques, processes, procedures, programs, or code, whether tangible or intangible, and no matter how it's stored, compiled, or memorialized physically, electronically, graphically, photographically, or in writing. So as you can see, this is very extensive. And there are two important aspects for information to be considered trade secrets. First, a company needs to take reasonable measures to keep the information secret. And I'll go through some things that you can do to ensure that trade secret information is maintained as such and confidential. And also importantly, information is only a trade secret if it derives independent economic value, actual or potential, from not being generally known or readily ascertainable through proper means. So that's the criteria for defining what may be deemed a trade secret. And I've included here on this next slide some guidelines that it's very, very important you keep in place so that all of the confidential, proprietary, trade secret information of your company is maintained as such. For example, confidentiality agreements. So for example, if you are talking with a third party, it's very, very important to have a confidentiality agreement in place that obligates them to keep any information that you disclose confidential and secret. Document disclosure, for example, having systems and processes in place within your company that not everybody has access to the confidential trade secret information. So there's a protection and a process for getting access to that. You also need to have physical security measures that you can show the company made efforts to keep that confidential and limiting access and disclosure. And also, this is very important. A lot of times, companies forget this. You need to mark the documents confidential, and whenever it's particularly when it's provided to third parties, so they know too it's being provided under the confidentiality agreement. On this next slide, I've listed what's considered misappropriation of a trade secret. It arises when information is disclosed or utilized in violation of a confidential relationship. And again, that's why it's important to have confidential agreements in place. And the elements include acquisition of a trade secret by a person who knows or has reason to know the trade secret was acquired by improper means, or the disclosure or use of a trade secret of another without express or implied consent. Under the Defend Trade Secret Act, there are, as I mentioned, there are a lot of benefits in terms of very powerful tools for protecting your company against unlawful theft of your trade secrets. And I included here a summary of those. The first one I have listed is the civil seizure mechanism. It's a preventative tool employed prior to a formal finding of misappropriation, in which a court, on ex parte application by a trade secret owner, may issue an order providing for the seizure of that that information to prevent the dissemination of the trade secret. You can also get an injunction from a court to prevent any actual or threatened misappropriation. However, there is a limitation on that. You can't prevent a person from entering into an employment relationship or place conditions on employment based on a perceived threat. It's got to be, you have to show evidence of actual evidence of threat and misappropriation, not merely this person has access to information. There's also a provision for a reasonable royalty, and this is in exceptional circumstances where an injunction is not equitable or feasible. The court may use this as one measure of damages to impose upon the entity that stole the trade secret what's deemed a reasonable royalty. And as I said, this is in exceptional circumstances, and there are very strict criteria for getting that. Once there's been a finding of misappropriation, a court can award damages. It can also award what's referred to as exemplary damages and attorney's fees, where you can show that it was willful and malicious in the misappropriation. And so the court can award those types of damages where it's appropriate. For example, if you can show it was stolen in bad faith, or there's a motion to terminate is made or opposed in bad faith. There are defenses to reverse engineering. So if you're ever accused of stealing or misappropriating trade secrets, if you want one example of that very valid defense is you reverse engineer it. So you didn't discover the trade secret through improper means. You actually, through reverse engineering, uncovered the technology. Or if you can show through independent discovery and development that it wasn't through an improper means. These are defenses to claims of misappropriation of trade secrets. The next category I want to talk about is patents, which is one of the most powerful forms of IP protection. Patents, as you may very well have seen in the news by companies such as Apple and other technology companies, they use patents to obtain a monopoly in certain inventions. Although many individuals may object to anyone having a monopoly on an idea or an invention, these rights have been a fundamental part of our patent system. Literally, it's in the Constitution. In Article 1, Section 8 of the Constitution, it says Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And the reason behind this is the government and the framers of the Constitution, they wanted to encourage individuals to share their inventions. And in exchange for sharing that, they've given them for a period of time, an exclusive monopoly for their invention. And again, that's to encourage individuals to, rather than keep it a secret or a trade secret, to share it with the public, but in exchange they get that monopoly right, so to speak. And now patents are governed under the Patent Act, which established the U.S. Patent and Trademark Office. And the most common type of patent is what's referred to as a utility patent. And I'll talk about that in a minute. They have a duration of 20 years from the date of filing, but they're not enforceable until the day they issue. There are also design patents for protecting ornamental designs of products. There are plant patents for protecting new varieties of asexually reproducing plants. And as I said, it's a government registration process. And importantly, one of the key rights that you receive from obtaining a patent is being able to enforce that patent and preventing others from infringing that patent. I've included here one of the hotly contested areas of patent law today is what is referred to as patent eligible subject matter. And there are four categories that are patentable for a utility patent. You can obtain a patent for a process, a machine, an article of manufacture, or a product, or a composition of matter, or a combination of any of these. And oftentimes, one of the areas contested is this patent eligible subject matter? So I've included, there's a two-step process for determining subject matter that's eligible to seek a patent on. And the Mayo Alice inquiry, it comes from two Supreme Court cases with regard to this topic of patent eligibility. And it's basically, you have to determine if the patent claims are directed to nature, natural phenomena, or abstract ideas, they're not patentable. They have to, as I said, they have to be directed to one of the four categories enumerated under the Patent Act. Now, to determine whether the claims considered individually or in combination transform the nature of the claims into a patent eligible application, you have to look at those claims as a whole, whether they fall into those statutory categories. So I included here, just as a side note, for software protection, as I said, there are multiple areas that you can protect software with. Patent protection is obviously a very important area, but there's also copyright protection and protection under trade secret law. One of the prior companies I worked for, we filed numerous software patent applications, and you have to, when I say software, those patents are, we refer to them as method patents, because you can't, in order to get a patent, it's got to be around a method of, rather than an abstract idea. And so one of the things that we came up against many times is oftentimes I find it very valuable to do a patent search to make an assessment of, first of all, can we even get patent protection? And secondly, if we can, how broad a protection can we get? And if we felt like, based on the patent search process and the relevant patents that came up, if we felt like, it doesn't look like we could get very broad protection, we would then make the decision to just seek protection through copyright and or trade secrets. Because if we didn't feel like we could get broad protection, we didn't want to basically put it out there in the public domain and provide a blueprint of how to design around our software or duplicate it with something that may not infringe. And so that's something to think about. As I said, I found it very valuable before filing for a patent application to do just a simple patent search to assess patentability. Now, the U.S. Patent and Trademark Office has established criteria for patent examiners to determine whether a claim is directed to unpatentable abstract ideas. And I won't go into the detail of this, but I'll just highlight by saying, if it's going to be abstract ideas or things like fundamental economic practice, or if it's a method of organizing a human activity or an idea itself standing alone, or a mathematical algorithm, it's not going to be patentable. So these are key aspects to consider in the process as well. I also included in here, for example, those software patents referred to as computer implemented inventions. There are guidelines and examples of what's referred to as prima facie unpatentable subject matter. So take a look at this list. As I said, there are things like economic practices, whether it's insurance or financial transactions, that are not going to be patentable. Legal theories won't be patentable. Mathematical concepts, as I mentioned previously, teaching concepts or instructions on how to conduct a business. These are going to be prima facie unpatentable subject matter. It's very helpful within a company, especially a technology company that develops products or technologies or software, that you have a internal process for identifying patentable inventions that you may or should consider filing a patent application on. And so I highly recommend implementing and with many of most all of the prior companies I was at, we had a patent review committee, and we would take a look at all of the new inventions, and sometimes we had employees, engineers that would submit ideas that the company decided not to commercialize, but it was such a great idea and had value that they decided to go ahead and file a patent application on that and seek a patent. So, with the idea that perhaps it could be licensed to other parties. So it's important to set up a process where engineers, inventors can alert the company that they have an invention. I had a simple form that they could fill out, an invention disclosure form that I included questions and they could fill out simple questions, and it would help me in the process and the committee in evaluating, is this something that may be patentable? Does it have commercial value to the company? And then also, before we invested money in R&D or development of a product, we always ensured that we had freedom to operate. And so we would do searches to assess whether or not we had that freedom to operate. So it's very, very valuable, especially for tech companies, to have a system in place and a team of people that can manage this process. We also we found it very helpful to offer incentives, particularly for tech companies wanting to increase and grow their patent portfolio, that we would offer financial incentives or stock options, things like that, or coming up with ideas and incentivize the engineers or other inventors to share their ideas and submit them to the company. And again, as I said earlier, it's important to remember there are statutory bars. For example, in the US, you have a 12-month period of time from when an invention may be publicly used or offered for sale, that you need to get a patent application on file within 12 months of that. But my policy was always, before there's any disclosure or offer for sale, get it filed, because particularly most of the foreign countries require what's called absolute novelty. And so you need to have a patent application filed first before you do any of that. So I think the best practice is having something on file before anything is shared. Now, oftentimes companies may come to the realization that, well, we need this patent protection, and we don't have the time to wait for filing a patent application and getting it issued, which may be a couple-year process. And so another option is to purchase it. And I've been at many companies where we had strategies for organic patent growth versus through acquisition. And I would, just add a side note too, one thing that can be done, because you need to be careful not to alert another company that you're interested in that patent, but if they decide not to license or sell it, they could then go after you for patent infringement. And so it's important to do that through a confidential process. And I've been involved both on the company side as well as on the legal firm side, where using outside counsel to approach a third party about licensing or acquiring their IP. And then that way, if it doesn't pan out, you haven't alerted them to your company and put a target on your back, so to speak. As I said, you can one option is to get a license, whether that's exclusive or non-exclusive. Now, and another option, if you can't either obtain a patent through internally or through acquisition or licensing, there are a couple of other options that you can consider. One is it may be that that particular troublesome patent is invalid. And so there may be, and you may have what's referred to as prior art or other evidence that shows that patent's invalid. But it's important to get outside counsel opinion, legal opinion that that patent's invalid, so that if you were ever sued for patent infringement, you can show you had a good faith basis to believe the patent was invalid and therefore you were not infringing it. Or another option, which is the one that I always recommend, is designing around that patent that may be troublesome, and also getting outside counsel's assistance and with a confirming opinion that you have effectively designed around that patent. So what do you do with a patent? You can use it offensively or defensively. Offensively, you can keep competitors out and protect, as we talked about earlier, that monopoly that you've been given for a period of time to keep competitors out. It can also be used defensively. Examples that I've personally been involved in are when, let's say, your company is sued for patent infringement, but you also have a patent portfolio that you potentially could assert your patents against that party alleging patent infringement. So it can be used as a negotiation tool to negotiate a license or a cross license. So they can be very helpful defensively. And as I mentioned, they can be a moneymaker. Some companies like IBM have a very successful business arm where they either assign or license IP. As I mentioned, it's very important to manage your portfolio wisely and to have a procedure or committee in place to stay ahead of disclosures or inventions that your engineers or other people may come up with. There's also excellent software tools out there where you can get a three-dimensional view of where you stand with respect to your competition with your intellectual property. It's also very valuable to review your competitors' intellectual property so that as new patents issue, you're aware of that and making sure that you have freedom to operate and that you are not infringing your competitors' patents. Patents are very effective in helping your company increase its market share and maintain a competitive advantage in that space. And through various financial mechanisms that can supplement the bottom line. I've included here a few examples of what I refer to as game changer patents. And these are patents that had a significant, technology that had a significant impact in our marketplace. And the first one I have here is the Amazon one-click patent. Since customers pay their payment and shipping information is already stored on Amazon servers, it creates, we all know, a frictionless process for checking out. And Amazon, this has been very, not only for protecting the one-click checkout process, but you may be aware, they licensed it to Apple. Apple licensed it for use with iTunes, iPhoto, and the Apple App Store. Now, this patent issued, and as you can see, it issued in 1999, but it expired in 2017. However, Amazon's trademark on the one-click continues, so there's still value in it, which is another emphasis of why you should consider all aspects of intellectual property protection, so that as this example shows, even though the patent expired, they still have the trademark, and so it still has value. The next game changer patent I included in here is the Alexander Graham Bell's telephone patent. Now, this patent is often considered to be the most valuable patent in history. And importantly, by restricting competition during a time of massive economic growth, geographic expansion and adoption of technology, it provided Bell with a monopolistic foundation that literally and essentially allowed it to rise to the level that it did and became one of the most dominant brands in American business through that patent. I've also included Google's famous PageRank patent. And long before AdWords, Google Glass, Android, and self-driving cars, Google's original vision was to improve the quality of search results. And this is the patent that they obtained on the method for node ranking in a linked database. I'm sure you all recognize Larry Page as the inventor. It was developed in 1996 by, at that time, he and Sergey Brin were Stanford grad students, and they came up with this idea. The basic idea was the information on the World Wide Web could be cataloged or ordered in a hierarchy by link popularity. So the more links a page had, the more popular it was, and therefore should be ranked higher. So obviously this was a very, very valuable patent. I have a couple of other examples here, just a couple of humorous examples. This first one is it's actually a design patent. It's the Filter 2000, the human gas filter pad for wearing in the underwear. And just kind of a humorous patent that was issued. This other one, pantyhose with 3 legs, and it was developed for in the event of a hole or a run developing in one of the legs, where it could easily and rapidly switch to the undamaged spare leg. Not sure how discreetly someone could change legs in a pantyhose quickly. I want to conclude with the importance of companies having the appropriate agreements in place with their employees, confidentiality agreements with third parties. And let me just focus on employees. It's very, very important to have, especially for tech companies and essentially any company, to have what is referred to as an invention assignment or a work product agreement, so that any ideas or inventions that employees come up with that are related to the business, the company owns that. And they're too often, and it varies state by state. I know Utah has, for example, an Employment Invention Act that clearly delineates those inventions derived by an employee that are going to be owned by a company. But rather than run the risk of relying on state law, it's a much better practice to have an agreement in place with all of your employees so that any of their ideas, whether it's patentable or trade secret or copyright, that the company owns that and can protect that. And then also having confidentiality obligations in their employment agreements, so that when they leave the company, they've agreed to keep all of the confidential know-how, trade secrets, information, proprietary and confidential to the company. Too many states and too many times, if there's not an agreement in place, an employee could say, hey, I came up with this idea at home. I was in the shower and I came up with this idea. It wasn't on company time or using company resources, and so it's mine. And to avoid any of those types of scenarios, it's very important to have an agreement with all of your employees to own the intellectual property and to keep it confidential. And with that, I'll open it up for any questions that you may have.
Great job, Paul. Thank you very much. Related to that question, and for those of you there, for all of you that are still with us, we've got some time left. Please feel free to submit any questions that you have, and we'd be happy to address them. Paul, I've got a couple of questions that have come in, but one that you just mentioned, that is related to the invention agreement and having all employees assign those. Would you take it one step further and have this be an adopted part of an employee handbook policy?
Absolutely, and that's what most companies do, so that even when they're onboarded, they have to sign off that I've read the agreement and I agree to abide by all the terms.
Okay, great. Thank you very, very much. This question is around NDAs, and it's really a three-pronged question. Should the company generally require each prospective vendor, supplier, and partner to sign an NDA? At what stage should an NDA be introduced? And then what's the typical duration for confidentiality obligations?
I would say in every instance, an NDA should be in place. And the time to do that is before sharing any confidential information. As far as the duration goes, I've seen anywhere from a year to 5 years. And one of the carve-outs for any NDA is if the information becomes publicly available, then it's no longer obviously confidential and protected under the confidentiality agreement. Whenever I can, and most companies on the other side are resistant to this, but I like to have specific language protecting trade secret information.
Okay, thank you. Let's go to the topic of trade secrets. You've had a lot of experience both as in-house counsel and leading corporate legal teams and overseeing intellectual property, and you've been on the private practice side of things. Could you talk to us a little bit about some real-life experiences of protecting trade secrets? Perhaps some that is the model, and some that perhaps have gone wrong.
I have, and this is it's an area where there's a lot of the courts and states they want to protect employees' ability to, when they leave an employer, to get a further work, and so they don't want to restrict that. And so there's a tension between protecting confidential information and allowing people to move to another company and have a livelihood. However, particularly with patents, and I've been in a situation where I was in a company where we had actually had a patent agent who was privy to all of the intellectual property and all the strategies for filing for patent protection, who then went to a competitor. And so I promptly sent a letter to the CEO and the general counsel of that company the employee went to, advising them that this individual had in his possession confidential proprietary trade secret and information on the company's not only proprietary information, but strategies for protecting its intellectual property. And frankly, I could see no way this individual could separate that knowledge and that information from their work. And, so unfortunately, it makes it when you're that specialized in something you do, it will oftentimes an employee will need to go to a different industry because if it's virtually impossible for them to separate all of the confidential information that they obtained from their prior employer in the new employment, then they may not be able to do anything. I've also, I practice in California where the courts are very pro-employee, and so I mentioned the importance of having employment agreements and invention assignment agreements in place. And through the years, I've carefully crafted key provisions, and one of those is you may have someone that leaves the company that just frankly is not cooperative in the future processes of seeking patent protection, where you may need a signature for filing in a foreign country or something like that. So I generally include in our agreements language that the company has power of attorney. So if that person, for whatever reasons, is unable to provide a signature or anything like that, that the company has power of attorney. So, again, these are very, very important to have in place, all of these types of agreements.
So, Paul, as you think about So, you've addressed the agreements and what companies should have in place. Let's talk a little bit tactically about how companies should go about protecting trade secrets. So for example, should all information be put in a segregated location? If it's digital, and if it's stored digitally, should it be put on a separate part of the network and have restricted access? I mean, what is your advice to in-house counsel in terms of protecting protecting IP and trade secrets generally?
If you are able to, ideally the best scenario is to have it on restricted access on in a database that only certain individuals have on a need to know and basis have access to it. And you can actually track who has access to it. I know that a lot of companies today they try to avoid any paper copies so that nothing can accidentally get leaked out or copies distributed. And so they restrict access to a lot of the confidential information electronically. And then they can keep track of who has access and track all of that. So, and if you're not in the position to be able to do that, it could be having a locked cabinet, file cabinet that you keep it in. And so the important thing is that you need to be able to show you've taken measures to protect the information, you've marked it confidential, and you've taken measures to enforce that. And all too often, some companies will, for example, like they'll put together a PowerPoint presentation and they forget to put confidential on it. And you just need to be diligent. Anything that you do, assume that it's going to get out and um, make sure that it's marked confidential. Email exchanges between companies and third parties as they're working on developing a product, they forget to, they just start. And, I always had to be very vigilant with our engineers that, guys, you gotta, everything that you share, every document, mark it confidential and just, you put it in your template, your PowerPoint template, put it in your template of any documents, mark it confidential. On all the drawings, mark them confidential. And the other thing I would say too, and I'm happy to, and I've done this many times at no charge to companies and clients, I'm happy to, come in and just give a primer on IP and remind everyone the importance of keeping things confidential. And so I think just the constant reminder of be be careful. Your intellectual property, that's your lifeblood. That's what sets you apart from your competition. And just do everything you can to keep it proprietary and keep it protected.
One final question, and related to this very topic, Paul, is give us your best practices on how do you educate employees on this? Obviously, they have to, sign policies and or agreements rather. It's in employee handbooks, but what are some best practices that companies can do to educate the employee base on the importance of these policies, what not to do, et cetera?
It's repetition. Even though they hear it, we get into our routines and our old practices and we forget. I think it's very important for management in particular to just repeatedly remind everyone about the importance of all of these topics. And one thing I'll say too, and this is a side note, my experience has been with most engineers or technical people is they're very critical about their inventions. They say, "Oh, that's obvious. Anyone would think of that." And I used to tell people, don't be the arbiter of that. Let us be the arbiter of that, because most things, most inventions, most patents today are a combination of known elements. But when you combine it in a unique way, it's novel. It's not. You may think it's obvious, but it's not. Nobody else has figured it out. I mean, that's what I would always say to the engineers. Has anyone else done this? Well, no. Well, then it's not as obvious as you think. And I can tell you of the patents that I've obtained have been on things that the engineer thought were, quote, obvious. So, yeah, I would just say be careful. I've seen it, I've heard it so many times. People say, "Oh, that's not patentable," or that's obvious. And it's if it was so obvious, then somebody else would have come up with it a long time ago. So let let the people with the expertise make that call. And so we would always assume it's patentable and then do searches to confirm that it wasn't. So I would default to assume it's patentable until you're shown otherwise.
That's a great tip. Paul, in the remaining minutes that we've got, any final takeaways that you want to share with our audience today?
It's a IP law is a very complex area of law, and even present company included, it's very fact specific, and I've heard all the comments from even senior executives of international multinational companies make comments like, what's the value of this, and they kind of view it as if a big company's got the prowess and the money that they can, patents or trade secrets don't matter. That's not the case. Uh, there, I can tell you from personal experience that, especially for small companies, small businesses, that is your value. I was involved in a company, a small public company that was acquired by a much larger public company, and after the deal was done, one of the senior executives said to me, he said, Paul, we had our outside patent counsel look at your IP, um, every possible angle to see if we could design around it, because frankly, we were trying to figure out if we could just design around your IP instead of having to buy you. And the outside counsel came back and said to him, "You got to buy him." And um, I know that we've gone through various cycles, which we do. Sometimes we go through cycles where um, the courts narrow or limit the scope of IP, and then other times the pendulum is swung back and forth many times, and we don't know what the current environment will be 10 years down the road. But I can tell you that from personal experience that intellectual property really is how you protect the value of your company. And especially if you're a smaller company, it prevents bigger companies from frankly just infringing your IP or designing around it. If you need to be very strategic in protecting all of your assets, whether they're copyrights, trademarks, patents, or trade secrets. So
Well, Paul, great job.
Go ahead.
Oh, go ahead. Go
I
ahead,
was just going
Paul.
to say, I want to thank everyone for their time today. I hope you found this helpful. And if you have any follow-up questions, feel free to reach out to me afterwards directly, and be happy to answer any questions that you may have.
Well, Paul, thank you very much for taking the time to be with us today, for preparing a really insightful and informative presentation. We really appreciate it. To all of you that joined us, I echo Paul's thoughts. Thank you very much for being with us today. If you have any questions, please don't hesitate to reach out to Paul directly. I will be providing you with his contact information. And as I mentioned from the outset, you will receive a copy of today's PowerPoint presentation, a link to the recording, and then we will also be requesting state bar information so we can submit CLE on your behalf. Again, thanks a lot for being with us today. Paul, great job. And don't hesitate to reach out to us if there's anything that we can do to assist you with your IP needs. Thanks, everybody. Have a nice day.